Marbury v. Madison, Dred Scott, Roe v. Wade. Most Americans would recognize these as Supreme Court cases whose decisions had significant implications for our country. However, there is a less well-known case that dramatically affected the way our country has been governed for almost 200 years. This case dealt with issues such as, what is the relationship between the power of the state versus the power of the federal government? What happens when the two come into conflict? Should the United States Constitution be interpreted narrowly or broadly? Today, Historical Spotlight will look at the 1819 Supreme Court case of McCulloch v. Maryland.
To understand McCulloch v. Maryland, we start with the Second Bank of the United States. On April 8, 1816, the Congress of the United States passed a bill that allowed for the incorporation of the Second Bank of the United States. The bank went into full operation in 1817 and was headquartered in Philadelphia, Pennsylvania. However, there was still a debate over whether Congress actually had the power to incorporate a private bank. The bank opened a branch in Baltimore, Maryland in February 1818. The state of Maryland then proceeded to impose a tax on the Baltimore branch. Maryland's intention was to tax the bank out of existence, at least in Maryland. James McCulloch, head of the branch, refused to pay the tax. Maryland then sued for collection of the debt. McCulloch responded that the tax was unconstitutional. Eventually, the Maryland Court of Appeals sided with Maryland. McCulloch then appealed to the U.S. Supreme Court. In 1819, the Supreme Court ruled unanimously in favor of the bank. To understand why most legal scholars see this ruling as a landmark decision, let us take a look at the historical context in which the Second Bank of the United States was formed. In 1791, Congress passed a bill authorizing a national bank. President George Washington, unsure of the bill's constitutionality, sought opinions from his cabinet. These opinions would eventually form the basis of the arguments in McCulloch v. Maryland. Secretary of State Thomas Jefferson articulated the arguments against the constitutionality of a federal bank. First, he argued that the creation of a federal bank is not an enumerated power. It's not in the Constitution. Second, such a power was rejected at the Constitutional Convention. Third, to argue that such a power is an implied power was an inadmissible reading of the Constitution. It would render the enumerated powers, the powers listed in the Constitution, meaningless. Fourth, the word necessary in the Necessary and Proper Clause meant indispensable, not merely convenient. Fifth, another argument came from James Madison, who believed Congress had not received the power to incorporate a bank or any other governmental agency. His argument rested primarily on the 10th Amendment, that all rights not endowed to Congress go right to the states or the people exclusively. Additionally, his belief was that if the Constitution's writers had wanted Congress to have such a power, they would have made it explicit. The member of Washington's cabinet arguing for the constitutionality of the bank was Secretary of the Treasury Alexander Hamilton. He argued, first, the Constitution granted Congress resultant and implied powers. These were powers that resulted from those enumerated in the Constitution and implied by the Necessary and Proper Clause. Second, the Necessary and Proper Clause ought to be read broadly. Third, Hamilton suggested a means-ends test. He said, if the ends of congressional legislation were constitutional, and if the means were related to them and are themselves not specified to be unconstitutional, then they should be allowed. Washington ultimately agreed with Hamilton. He signed the bill and the bank was created. However, the bill eventually expired in 1811, and the bank was allowed to dissolve. Following the War of 1812, our new nation found its monetary system to be in a particularly precarious position. Private banks were allowed to print their own notes, which were not necessarily redeemable in specie. Since these notes did not have to be redeemed in silver or gold, there was little restraint on the number of notes printed, and thus the money supply expanded wildly. Sound banks, usually those whose notes were redeemable in specie, began refusing to accept notes issued by unsound banks. This caused enormous uncertainty in trade and business. Two ways of dealing with this problem were considered. The old Republican Anti-Federalist path was to have the federal and state governments force inflationary reckless banks to redeem their notes in specie. When these banks failed to do so, they would be liquidated and their notes forced out of circulation. This would return the economy to a sound money footing. The Old Federalists, however, advocated a different path. They argued for a central bank modeled closely after the first Bank of the United States. The country chose the second path. The Second Bank of the United States was created in 1816. It was established as a private corporation with 20% of its stock owned by the federal government. The bank's official mandate was to create a sound economy by the following means: create a uniform national paper currency, purchase a large part of the public debt, receive deposits of treasury funds, and require Bank of the United States notes and deposits to be redeemable in specie. On the surface, it may seem that the Second Bank of the United States was a pretty good idea. However, soon after it started operations, the bank began to massively inflate the money supply. During 1817 and 1818, its specie never rose above $2.5 million. However, its loans totaled $21.8 million. Thus, in a mere year and a half of operation, the Bank of the United States added a net of $19.3 million to the money supply. Senator William H. Wells, Federalist from Delaware, noted in some surprise that this bill came out of the hands of the administration ostensibly for the purpose of correcting the diseased state of our paper currency by restraining and curtailing the overissue of banking paper, and yet it came prepared to inflict upon us the same evil, being itself nothing more than simply a paper-making machine. The abundance of cheap credit fostered an economic boom and created a real estate bubble that sharply raised property values around the country. However, beginning in the summer of 1818, the Bank of the United States became aware of the dangerous inflationary climate that was emerging. In response, it proceeded to engage in a series of deflationary moves. This led to a wave of bankruptcies throughout the country, a collapse of real estate prices, and subsequently the Panic of 1819. An economic depression ensued that lasted until 1821. William M. Gouge, Jacksonian hard money economist and historian, stated, "By its dramatic contraction, the bank was saved and the people were ruined." As the country was reeling from the severe economic decline, there were charges of extensive fraud at the bank's Baltimore branch. It would surface later that the officers had looted almost $1 million from the bank. Needless to say, many people were unhappy with the bank. Indiana and Illinois in 1816 and 1818 respectively amended their state constitutions to prohibit the Bank of the United States from operating there. North Carolina, Georgia, Maryland, Tennessee, and Kentucky imposed heavy taxes on Bank of the United States branches. In April of 1818, James McCulloch, cashier of the Baltimore branch, refused to pay the tax imposed by Maryland. McCulloch contested that such a tax was unconstitutional. Maryland sued McCulloch, and the case went to court. In the Maryland State Court of Appeals, Maryland put forth the argument that the Constitution is silent on the subject of banks. Since the Constitution did not specifically state that the federal government was authorized to charter a bank, the Bank of the United States was therefore unconstitutional. The court ruled in favor of Maryland. The case was then appealed to the Supreme Court. The case was argued for 9 days before the Supreme Court. Arguing for and against were some of the smartest legal minds in the country. Arguing for the bank were Daniel Webster, U.S. Attorney General William Wirt, and William Pinckney. Arguing for Maryland were Maryland State Attorney General Luther Martin, Joseph Hopkinson, and Walter Jones. After 3 days of deliberation, the court returned its verdict. The court unanimously determined that Congress did have the power to incorporate the bank, and states could not legally interfere with federal law. John Marshall wrote the opinion.